You said I was.
I apologize, Your Honor, I didn't hear. It's Ms. Rodrigue.
All right. You may proceed.
Thank you. And this is Laura Rodrigue, Special Assistant Attorney General on behalf of Anthony Dorris and Justin Leonard. The case before Your Honors today essentially comes down to the issue of qualified immunity and whether qualified immunity should be applied to Mr. Dorris and Mr. Leonard, both state troopers with the Louisiana State Police. The issue before this court is first and foremost one where there is no federal jurisdictional law that controls this particular issue of whether a search warrant can be issued for a person who is deceased. That's essentially the issue that has come before the district court in this case, whether or not the state troopers, after fatally shooting a person in their home, could execute a search warrant in the home after the person was deceased. In this particular case, the fact that there is no clearly established law which squarely governs the issue essentially means right out of the gate, without having to go any further, qualified immunity should apply to both of the troopers in this particular case. However, the district court goes on to analyze whether or not the dispositive issue, as the district court calls it, is whether or not probable cause exists to support a warrant to search for evidence of a crime that cannot lead to the prosecution of a criminal. Essentially, what happens in this case is a phone call goes out indicating that shots are being fired outside of a residence. The Houma Police Department arrives on the scene of the residence, and there...
Are you saying that call went out, was that specific? I thought the call went out that there were shots being fired in a neighborhood.
That's correct.
You're saying there were shots being fired at a residence and they went straight to the residence.
I apologize. You are correct, Your Honor, that the shots are being fired in the neighborhood, and the officers arrive to that location where the call comes from, and they locate the person in his vehicle who becomes the deceased.
What do you mean, the person?
The deceased person, who will eventually become the deceased person. They
But
locate...
the call was about shots being fired in the neighborhood, and now you're telling me that they were certain when they went out that Mr. Nevarez was the person firing the shots, so you saying they located the person?
They are able to locate the person where the shots are being fired from. Yes, Your Honor. That is Mr. Nevarez, correct. They go to the location where the shots are being fired, and they locate Mr. Nevarez. That is, and he is at his residence. At the time, he subsequently goes into his vehicle. The officer approaches the vehicle, attempts to tell him, to engage with him, telling him to exit the vehicle. He will not exit the vehicle. The officer pulls his service weapon in an attempt to get Mr. Nevarez to exit his vehicle.
Counsel, we know the facts, and there are some tricky little legal issues here. So,
yes.
Am I correct that they're two separate issues? The district court, essentially applying Hayden, said that there's no evidence that could ever be obtained because you couldn't get a conviction, you couldn't apprehend anybody because the suspect is deceased. But
Right.
then that's one argument that you'll have to respond to. But then it seems to me that plaintiffs now on appeal to us are saying something different. They're saying this is just a Malley case. When you look at these affidavits, there was no effort to show a nexus between the home, the car, the cell, and the assault. So you need to respond to both.
Yes, Your Honor. The Hayden case, which is first used by the district court, the facts of that case are distinguishable from this case. In the Hayden case, the officers are pursuing an armed robbery suspect. They are in active pursuit of an armed robbery suspect. The armed robber flees inside of a home, and the police pursue the armed robber to the home, where the person then says, it's a random home, and the person says, you can enter my home and find the suspect in here, which they do in an upstairs bedroom. That is a completely different case from a case where a magistrate has signed a search warrant for the search of the home and the vehicle, which are the location of the actual crime of aggravated assault.
Why did they say in the warrant, why did they say they were conducting the search? What did they say was the reason for the search?
The reason for the search is that an aggravated assault is committed by Mr. Nevarez. That is the crime that essentially they are there.
But they said they were investigating an aggravated assault on a law enforcement officer.
Yes, and
Weren't
the
they
warrant...
actually, though, told that they were supposed to be investigating an officer-involved shooting?
Well, Your Honor, that's in the warrant as well. They indicate in the warrant that they're investigating an aggravated assault. These two incidents they don't separate, they don't exist as islands on their own. The officers do not omit any of that from their warrant. In fact, it goes on to later say evidence involved in the shooting, okay? The aggravated assault is not a shooting. There's not a discharge in an aggravated assault. It's the pointing of a weapon.
You're not arguing that this affidavit was actually asserting probable cause relating to police misconduct, are you? They weren't going to find anything that would reveal why the police shot him.
Your Honor, they were...
Right? The affidavit says the offense for which there is affidavit probable cause is the assault on police.
Correct.
Okay.
Aggravated
So
assault.
the question is then, what evidence could they possibly have found in the home, in the car, the cell, that would lead to the apprehension or conviction of anyone if he's dead? That's what the district court found difficult.
Yes, Your Honor. So I guess let me back up and say that I agree with you that the aggravated assault is the incident that leads to obviously the police shooting. What the district court finds is that what is necessary in the search warrant is that the evidence obtained would lead to a conviction of the person being arrested for whatever evidence is received by the troopers at the time. That is simply not the law in terms of a search warrant. In fact, in Gates, the court has held that the purpose of a search warrant affidavit is simply to establish that there is a fair probability that contraband or evidence of a crime will be found in a particular place. Notice, the Gates court does not then go to say that a warrant has to lead to a conviction because we don't saddle law enforcement with the job of charging or convicting. That's not the purpose of a warrant, and we don't put that responsibility on a law enforcement officer when they're drafting a warrant. The responsibility to charge is with the district attorney or with the United States attorney, and the responsibility to convict is with a judge or a jury. That is simply inapplicable in this case to say that a search warrant must only be obtained and is only lawful if it is expected to result in a charge or a conviction. Search warrants all the time do not result in charges.
So you're not disputing the district court's finding that there was no evidence at all there were other people involved in the assault. So they weren't trying to get evidence to see if there were others involved. The district court makes that finding on page 19.
Well, I think the district court ignores the fact that, first of all, somebody from the neighborhood obviously calls indicating that shots are being fired in the neighborhood. I would consider that another person involved. These are all a series of events. They're not taken in isolation. The other people involved are the troopers who had a gun pulled on them.
Does the affidavit say we think there are other people, yes or no?
The affidavit lists the Houma Police Department officers who are forced to take deadly force. So,
Okay.
of course,
I asked you a specific question. Does the affidavit say that the police thought there were other people they were still looking for? Yes or no?
No,
Okay.
not as to other people.
So then I assume they're looking for evidence of his alleged shooting, instrumentalities and evidence. What evidence were they searching for?
They specifically state that they're searching for anything that could have been surveillance to capture the incident inside the home, whether the home had any surveillance footage of the incident, which would have occurred right outside the home. The phone that they're looking for, Mrs. Nevarez is...
Well, now, surveillance, how is that evidence of his crime assaulting them? Wouldn't that be more what Judge Vance thought was happening, which is that would be evidence that maybe, in fact, there wasn't justification for lethal force?
Well, the same surveillance would capture both incidents, correct? It would be an aggravated assault. He has to pull the gun first, and then the officers fire back. There's not any dispute about that. The surveillance would have to capture both. They're within the same vicinity. So the evidence, the warrant indicates there's an aggravated assault that precipitates into the officers having to use deadly force. We would expect all of that evidence to be captured pursuant to any surveillance. It all happens in the same area. The same goes for the cell phone. She is in direct communication with Nevarez when they are in where they're in sort of a standoff with him, where he's refusing to cooperate. Of course, what is being communicated, texted, or whatever between him and her is relevant in terms of the aggravated assault committed, whether he's saying, I'm going to pull a gun or whatever it may be. Those pieces of evidence are certainly relevant in terms of the aggravated assault.
It does come back to Hayden then, right? It's intuitive for the district court to say, but why do they want it if he's dead? What are they going to use against him?
Well, Your Honor, again, that's simply not the requirement of whether or not there's a Fourth Amendment violation, of whether he will be ultimately able to be convicted. The question here is...
Well, we see it all the time in Fourth Amendment search warrants that are stale. If the affidavits are stale, you don't get the warrant.
Well, Your Honor...
Right? And here it's stale in the ultimate sad, tragic sense. He's dead. There's nothing left to get.
And I guess, let me, again, just distinguish from Hayden, again, which is a very different set of facts from these particular facts, which is why both the district court and, Your Honors, we agree that there is no case law controlling in this particular issue. There's been no dispute about that. In fact, the district court comes back and cites a case on a motion hearing out of Michigan, and a completely different circuit, completely different facts as well. There is simply no case law controlling here. The question becomes then, if there's a Fourth Amendment violation simply because the decedent cannot be convicted of a crime. And we would argue that that is simply not the way the law is set up. We do not say that police... You
may be right. There's no law. And what you're saying here now, though, I think is quite a bit more than was in this affidavit. That's the Malley problem, right? In other words, now you're suggesting, well, they were looking for other people, the people that were on the phone. Or, oh, actually what they wanted was the surveillance equipment. But I don't remember that the points of nexus that you're drawing to our attention were presented to the magistrate. Am I wrong? Did they say, nowhere in that affidavit does it suggest that there are other people that are colluding with him to shoot at police?
No, I don't believe that there's any indication that there's collusion going on with the person who commits the aggravated assault, but it does indicate that they're looking for, straight from the warrant, that they're looking for voice messages, text messages, pictures, electronic data, media contained within the hardware or cellular operating system of the phone. They're looking for any communications with her at the time of the standoff. Yeah. Any voice or text messages.
Could you clarify just one point of disagreement factually? In your brief, you said it's undisputed that he had a gun. And then in their response brief, there is a footnote saying, no, we do dispute that. Could you just clarify what the record tells us about his possession of a gun that justified the shooting?
Well, Your Honor, he's found to be in possession.
Okay, at the crime scene next to his body, there was a gun.
Yes, Your Honor. So there is...
But the officer that went up to his window didn't see one. It's just what's found when his body is there.
Correct, Your Honor.
And so, okay.
Yes. So the officer, in this particular case, I think as the court pointed out, that while we may all agree that there is no case law, essentially our conversation ends there. Because for qualified immunity, if the officers had no guidance to believe that their actions were unreasonable, then we don't get any further than that.
What would they investigate?
Well, Your Honor, they would investigate the aggravated assault that was committed. And essentially think about it in these terms. Wouldn't we expect law enforcement to follow...
An aggravated assault that was committed by
Mr. Nevarez.
Other than the decedent.
Correct. So we would...
Someone other than the decedent is what they were investigating.
They're investigating...
An aggravated assault by the decedent.
Correct, Your Honor.
For purposes of prosecuting the decedent?
Well, no, Your Honor, but we would certainly expect that law enforcement would follow up with an investigation. Just as if a person is killed on a scene, it doesn't
Didn't the Houma Police Department ask them to investigate the officer-involved shooting? Isn't that what they were supposed to be investigating?
Actually, the Houma Police Department called him out to investigate.
They asked Louisiana State Police to investigate an officer-involved shooting.
Well, yes, technically the state police usually investigates the local, they get an unbiased...
But that's not what they put in the warrant. That's not what the warrant says.
Well, Your Honor, the warrant, in other words, they can't separate the two incidents. There is no way for them to ask the state police to come in here and say, investigate an officer-involved shooting, but ignore the aggravated assault that happened first. They have to come in sequential order. First is an aggravated assault. It leads to the officer-involved shooting.
So if they had just said we're investigating an officer-involved shooting, they would have been able to get a warrant to search Mrs. Nevarez's cell phone with that warrant. That just said, I'm here to investigate an officer-involved shooting.
Your Honor, I would assume you'd have to give the same exact specifics. I think the warrant would be the same. That's the whole point. The warrant wouldn't change. They have to lay out the truth in a warrant. They have to tell the judge.
Well, the truth, so you're saying the truth is they were investigating an aggravated assault against committed by a dead person.
Correct. And Your Honor, that's the truth.
For purposes of, again, tell me what the purpose was if he's dead.
Well, they have an obligation. Do we not believe that they have an obligation to follow up with the crime? And let me put it this way, Your Honor. Imagine if Homa Police had gotten a phone call in a neighborhood, okay?
I'm not doubting that they have an obligation to investigate it. I'm questioning the veracity of what they put in the warrant.
They never omitted anything. In fact, the district judge, he knows the person is dead. They haven't omitted any facts. And the district court, even in giving multiple attempts at amending this petition, the district court never finds that there is not a nexus here or that the warrant is not specific enough. The district court is merely saying, can you execute a warrant on a person who is dead when it cannot result in a conviction? We are arguing they are simply distinguishable. You cannot saddle Fourth Amendment.
Counsel, your time has expired. Thank you very much.
Thank you, Judge.
Judge Higginson has another question.
Just that last remark that they can get a warrant whenever they're investigating a crime where the suspect's dead. So if it were as it was here, entirely outdoors, but instead of a single family, there's an apartment building. Are you saying that they would have probable cause to go into every single apartment to see if there was surveillance of the scene?
No, absolutely not. I think and the warrant doesn't do that here. The warrant limits it to exactly what's in the scene. In fact, the district court relies, the last case that the district court relies heavily on, the Coopshaw case, where there is a traffic pursuit.
Okay, you don't need to go field. You'll have rebuttal time. You answered my question, he gave you extra time. Appreciate it.
Good afternoon, Your Honors, and may it please the court. Xakema Henderson, I represent Plaintiff Appellee Mrs. Julie Nevarez. Now, contrary to the arguments you just heard, and as the court picked up on, this court is not here today to resolve a novel issue of law. Defendants are just wrong in saying that the clearly established law that's at issue is whether or not a search warrant can be issued to investigate a crime where the criminal suspect is deceased. That's not how the district court framed the clearly established right at issue. What the district court said is that Mrs. Nevarez alleges defendants violated her clearly established right to be free from a search pursuant to a warrant that lacked probable cause on its face under the Supreme Court's 1986 decision in Malley v. Briggs.
Okay, I have two preliminary questions. Let's imagine Mr. Nevarez didn't die. Would you agree then this affidavit would be absolutely fine? It would establish probable cause?
No.
Why not?
Because there's no nexus between the actual items that are listed in these affidavits to be seized and the alleged criminal conduct.
But it's his car and it's his house.
Correct.
And he's alive, and he's just shot at police, and they want to confirm and obtain evidence, even instrumentalities. Let's say his defense is going to be, no, you planted that gun. And lo and behold, if they go in the house, they find ammunition that matches the gun. That would be immensely important corroborating evidence.
And we don't dispute that. I think the problem which Judge Graves alluded to is what's actually in the affidavits themselves. The affidavits don't actually identify or explain what the connection is between what they're searching for and this alleged aggravated assault on an officer that occurred, Your Honor, outside of the house, away from the car, in the front yard. And I will say, I'll concede that it's a grayer area if he's alive, but I think that's why the district court focused and emphasized the fact that he was deceased.
I know, but that's my second question. Your brief at 24, you say, quote, that circumstances involve the deceased suspect is of no moment. Your brief says that the circumstances here involve a deceased suspect that is of no moment, whereas I read Judge Vance as saying that's the crucial fact. And your brief is disavowing that.
And that's because we emphasize the nexus.
Not just emphasize, you are not defending the ruling of the district court, the Hayden logic, that there has to be someone alive. Your argument to us, at least unless that sentence, I'm misreading it, is this is just a Malley claim, easy, there is no PC because there's no evidence connecting an assault, even if in a living defendant, and stuff that they might want to get from the car that he exited from or the house he might have gone into. Is that correct?
Yes and no, Your Honor. The classical lawyer answer sort of depends, right? So it's twofold, right? The district court came to two conclusions. One of those conclusions is the fact that Mr. Nevarez is deceased and cannot be prosecuted. And that's the only finding that the defendants will acknowledge. But if you look at the district court's order, they emphasize this other piece that there has to be a nexus.
And you're only defending, your argument to us is to affirm on that basis.
Correct. And if I may, Your Honor, give you an example of why it gets trickier when he's alive and why we believe the district court emphasized his death is in the Supreme Court's 2012 case, Messerschmitt versus Millender. There you had a criminal suspect who was accused of domestic violence. He fired his shotgun at his girlfriend 5 times, and the police subsequently got a search warrant to search his home. He shared that home with other people. Those people subsequently brought a 1983 claim saying that the search warrant was overbroad. The search warrant there sought 2 large categories of information. Or evidence, I should say. One was all firearms in the house, not just the one that he was accused of using.
But your attack here is in scope, right? You're not saying overbreadth.
Sure, indulge me, Your Honor, indulge me. The second part of the search warrant was about the gang affiliation of the suspect because he was accused of being a part of a gang. And what the plaintiffs argued there was that those were both overbroad because evidence of his gang affiliation could not be used, right? And other guns that may be in the house also could not be used. And what the court said there was, no, exactly to your point about if he were alive, these items would be able to be used in his criminal prosecution, whether it's to impeach him, whether it's for his defense, or what have you. It's in the prosecution that evidence becomes relevant. But the fact that he is deceased, Mr. Nevarez here, it cuts off that analysis. And if you look at Messerschmitt, it's 4 different opinions. It's a majority, it's a concurrence, it's a concurrence in part, and it's a dissent, because all the justices are talking about the same issue of if this evidence can or cannot be used in his defense, is it overbroad or not? Here, with Mr. Nevarez being deceased, we don't have that sort of gray area where we're having to discuss whether or not this evidence could be used in his prosecution or in his defense. And to counsel's point that the police are not the ones who are making the decision of what to do with the evidence, that sort of proves our point. They collect the evidence to give to a prosecutor who then decides whether or not they can prosecute or if they want to prosecute. Here, with Mr. Nevarez being deceased, the prosecutor has no decision to make. He cannot be prosecuted.
I'm just confused. That seems inconsistent with your statement on page 24.
Your Honor,
it is of no consequence that he's dead.
That's our position. And what I'm saying is our position is it isn't, because ultimately there is no nexus if you're looking at the affidavits at issue here, okay? We can talk about different scenarios and different situations.
Well, let's just put that one to bed then, unless this is an overstatement. Is there any clearly established law other than Cooper-Shaw that stands for the proposition that if the only suspect's dead, there can be no further investigative techniques under the Fourth Amendment? Can you give me a case?
We fundamentally disagree with the premise that...
With that characterization?
Yes.
So that's why you're not defending.
Malley is the clearly established...
Malley is the clearly established.
Coop-Shaw is illustrative of Malley. Coop-Shaw cites Malley. In Coop-Shaw, the defendants did the same thing there, where they tried to come up with this creative argument that there is no clearly established law that says...
But I'm just trying to... There are a lot of little pieces moving here. It's
Sure.
not relevant. It's of no moment that he's deceased. And nor is it any... This is not an inquiry in the subjective intent, that in fact these officers might have been trying to find ways to exculpate their shootings. That's not relevant. So it's just a Malley nexus inquiry, yes or no?
Yes, it's a Malley inquiry. And the reason I hesitate, Your Honor, is because probable cause is an inquiry about the totality of the circumstances. So when you're trying to isolate any one of the circumstances, it detracts away from the fundamental core of conducting a probable cause analysis. We have to consider the fact that he's deceased. We have to consider the fact that Homa Police Administration asked the defendants to investigate their own use of force. We have to include the fact that the incident is self-contained and happened outside of the property, away from the car. You have to consider all of these things in their totality.
I'm not disagreeing.
Okay.
I'm just thinking in a Malley claim, we just look at the bare bones affidavit. Is there PC, yes or no? And it has to go to each item search. There's got to be a nexus. That's all that I understand.
Well, Malley says more than just bare bones. It says if the affidavit is conclusory, right? So it's bare bones, conclusory, or otherwise does not provide evidence that suggests that probable cause is there. And so, yeah, I agree that you can just look at the affidavits here, and they don't establish a nexus between the alleged aggravated assault on a peace officer and the items to be seized and the places to be searched. And I think Mrs. Nevarez's cell phone is a really great example of that. What they're saying is that she had her phone and called him or spoke to him during this incident. Number one, we allege in the complaint that the officers seized her phone and she didn't have it that night to talk to him. But even if you accept what they're saying is true, what they're saying is if any one of us is called by someone who commits a crime close in time to having called us, there's probable cause to search our phones for evidence of that person's crime. I mean, it's ludicrous under the Fourth Amendment. It just doesn't carry weight. So ultimately, our point is, if you look at the totality of the circumstances.
I'm not sure I accept that that's ludicrous. I mean, if in the middle of his refusing to put his window down and then the running, and they allege he then raised a gun and aimed at them, he's also calling somebody else. Why wouldn't that be evidence, possible evidence, of the crime?
In his phone.
No, his call to that person.
Right, his call to that person from his.
Simultaneous with the alleged assault.
That they would have probable cause to search her phone.
Get evidence of him saying, I'm about to shoot a police officer.
I fundamentally disagree that the Fourth Amendment permits that. I mean, we're saying, number one, let me take a step back because I don't want to get too far in the weeds. This is a motion to dismiss, okay? We have alleged in the complaint that the officer seized her phone. She did not have it to communicate with Mr. Nevarez, right? Those are the facts that the court has to accept as true. And so if you accept that as true, then Mr. Nevarez commits this alleged aggravated assault of a peace officer in the front yard. He does not have the cell phone. Based off of that and based off of the affidavits, there's no nexus connecting that criminal conduct with what they're seeking from her cell phone. And then, if I may, Your Honor, address Hayden. Ironically, defendants cite at least two cases in their brief in which they're citing to Hayden indirectly, right? So they cite, for example, Kohler v. Anglade and then Messerschmitt, which I just alluded to. And those courts are relying on the exact same language in Hayden that they're saying does not apply here. Second, defendants argue that the district court improperly distinguished that case because there was a warrantless search. But if you look at what the court is actually saying, it's establishing how you identify when probable cause exists for evidence that is not directly related to the alleged crime. So in Hayden, the court said, if the crime relates to if we're talking about fruits, instrumentalities, or contraband, that's direct evidence of a crime, right? If someone commits a robbery, the gun, the weapon is direct evidence. But when you're talking about mere evidence, things that are indirect, they're not clearly related to the crime, what Hayden said is that there has to be cause to believe that the evidence sought will aid in a particular apprehension or conviction. So the focus is not so much on the fact that that was about warrantless searches. The focus was on the fact of how do you tell that probable cause exists when you're not talking about direct evidence. If we're talking about this case and it being aggravated assault on a peace officer, defendants are claiming the gun was found in the front yard of the house next to the decedent. It begs the question of what they were searching for. It had to be mere evidence. And if you're putting a warrant affidavit in front of a magistrate to determine whether or not probable cause exists, the magistrate has to determine whether or not the evidence will aid in a particular apprehension or conviction. And I would add, too, that the Supreme Court said that consideration of police purposes is required in those instances. So I think with Hayden, one of the things it says in there as well is that there has to be a nexus between the evidence sought and the alleged crime. This idea of a nexus is our response to them saying that these affidavits state with exacting specificity, those are their words, exacting specificity, that there's a nexus. And our response to that, Your Honor, is that there is no nexus.
I think I might be repeating myself, but I'll say it again. And if you're saying that the fact that he's deceased doesn't matter, so we can assume he's alive. He shoots at the police, he's alive. He shoots from getting out of his car in front of his house. You're saying there's a case that would say there's no probable cause for the police to go see if there's ammunition that connects to his gun in his house and his car? That fact narrative given in the affidavit is a probable cause?
I don't know that that case exists, but
wouldn't that be the most elementary first step anyone would do? Aggravated assault on police, out of car. That gives them PC to go in the car, no?
not necessarily, Your Honor, because
What's the case? I mean, that would be the most obvious case of probable cause.
there's no case that we've cited or that the defendant's.
But he's just gotten out of that vehicle.
Right, but look at the crime, Your Honor. It's aggravated assault on a peace officer, and they're alleging that he was in the front yard. The car's in the driveway. He's in the front yard. He's away from the car. He raises his gun, allegedly, to the police officers. That it's a self-contained crime. And so they thought enough of needing probable cause to also go get a search warrant.
I agree. I think that's the phrase you used throughout your brief, self-contained. But I wonder where that appears in Malley case law, because you're not denying he starts in the car. Right before the alleged shooting, he is in the car in front of his house. So your theory of Malley is they can't look in any place that he owns, he's the owner, minutes before the shooting occurred. No?
Two things. One, because we're here on a motion to dismiss, we're basing it off of what we've alleged. And the defendant's conduct here is determined based off of plaintiff's allegations. That's the first thing. The second thing, we've alleged that there's nothing that connects the alleged aggravated assault to the car itself as set forth in the affidavits. So we say in our complaint that Mr. Nevarez was never observed committing any illegal behavior in the car. Mr. Nevarez was never observed with a gun in the car. We state that the officers say they don't see a gun, so he's outside of the car and in the front yard. So in our estimation, there's nothing criminal related that connects the alleged aggravated assault to the car itself. And out of the three places that were searched, the car, the phone, the house, maybe the car is the one that's sort of the grayest, but our position is still that the alleged crime occurred outside of and away from the car. And if you look at the actual affidavits, they don't articulate anything that relates to him being in the car as connected to the aggravated assault, other than that's where he was before. And so you can't say because he was there before and now he's in the front yard, that alone is the nexus. And if they want to say that, they could have. That's not in the affidavit. I would also point out a few other allegations with the little bit of time I have left. This idea of the word nexus and whether or not plaintiffs have made this argument. In our opposition to their motion to dismiss, we only use the actual word nexus one time. But if you actually look at our allegations and you look at our arguments, we're clearly making a nexus argument, whether the court or defendants want to use nexus or basis or what have you. In paragraph 65, we allege that Leonard's affidavit represents that the Louisiana State Police sought to search the Nevarez home for firearms, notes, communications related to aggravated assault upon a peace officer without specifying that anyone was still living, let alone residing in the home. And I'd stop there to focus on Coopshaw, because Coopshaw is a Malley case. And just like in that case, the officers tried to search a property that was shared by the decedent and her mother to find exculpatory evidence or what have you. And the court found that, yes, because the decedent was dead and couldn't be prosecuted, that showed there was no probable cause. But what the court also said was this affidavit doesn't suggest that there's any ongoing criminal activity or that anyone else was involved in the crime such that probable cause could exist to search these places. And so that's the reason why we've drawn the analogy to Coopshaw, and in our estimation, we believe that's why the district court relied on it. But we are not citing, and I want to be clear, we're not citing Coopshaw as an example of the clearly established law, because we think the clearly established law at issue is Malley. And then also, Your Honors, I would also respond to their point about Gates. Gates is not somehow separate and apart from your typical probable cause analysis. And in fact, the focus there was not about where you could search. The Gates court subscribes to the same notion that there has to be a nexus between the crime that's alleged and the items to be seized or the place to be searched. And then lastly, Your Honor, I would just point out for the clearly established law issue that the Supreme Court has said the purpose of that prong is to provide fair warning to police officers. And what they have said is that the point is to prevent plaintiffs from converting the rule of qualified immunity into a rule of unqualified immunity simply by alleging violation of extremely abstract rights. And our point here is that Mrs. Nevarez is not alleging the violation of extremely abstract rights. She's alleging that her house, her car, and her phone were unconstitutionally searched pursuant to affidavits that are facially invalid. And so we would ask the court to affirm the district court's denial of the defendant's qualified immunity and allow this case against these defendants to proceed through discovery.
All right. Thank you.
Thank you, Your Honors.
Rebuttal.
Your Honor, opposing counsel ended her argument by saying we would ask this court to affirm the district court's ruling, but after argument, we know for none of the reasons that the district court ruled. We have just heard that they are absolutely abandoning the idea that this warrant is not valid because the person is deceased, which was the finding of the district court judge. They are disagreeing with that being the basis for the ruling and asking Your Honor.
We have to agree with you then that that's the sole basis for the district court's ruling, right? In order for you to prevail, we have to agree with you that that's the sole basis for the district court's ruling.
Yes, that the district court would not have ruled that way but for Mr. Nevarez being deceased at the time of the warrant. That is basically the case law that the district court uses in order to make this analysis.
If there's some other basis in the district court's order for its ruling, then you lose.
No, Your Honor, I would argue that the district court could find no body of law that would support the position that a warrant could not be issued if a person was dead. The district court admits that. They have no basis of law there. So we have.
I'm not arguing that, but your point now, though, is that that is the sole basis for the district court's ruling. Isn't that what you're saying?
Yes, I would argue that the district courts, I mean, I can't speak.
Ms. Henderson, I think, is saying they're actually part and parcel of the same thing. That Judge Vance looked at this and said, there's no one left alive. So I'm skeptical you had any nexus to find any evidence of a crime that's over. And therefore, she then does say the equivalent of, there is no nexus. I don't see the PC for the evidence you're trying to get. I don't see them abandoning it. I think what they're saying is the two are inextricably tied.
Well, Your
One
Honor,
leads to a Malley violation.
just as Your Honor pointed out when you asked counsel, does this change if the person is alive? And that should answer the question for you. They indicate no. In other words, we don't even believe that if he's alive, that they have a right to execute these warrants. Counsel said there would be no lawful right to execute a warrant on the cell phone because he wasn't the one speaking on Mrs. Nevarez's cell phone.
But that wasn't, you want to save your time. That was my hypothetical. It isn't the facts here.
Correct. And
the only person that could have assaulted the police is dead. And therefore, I'm still trying to figure out what it is that they have PC to get to connect to that assault.
Well, Your Honor, just because the person died doesn't mean a crime wasn't committed. And think of it in an example of a school shooter.
Okay. Let me ask you the same question I asked them. You'd think there'd be lots of cases. Sadly, people do die often. Do you have a single case where an affidavit is upheld? Can you think of a case where the affidavit's upheld, seeking PC after the crime is concluded, there can be no conviction? Can you think of a case?
No, Your Honor, and that's why qualified immunity applies here, because there is no presiding law for this court or to guide those officers. So before we even begin analysis of nexus, it doesn't exist here. This case, there is nothing.
A fair inference would be there's no case because it would be a 1983 violation. You'd violate the Fourth Amendment if you start going into everyone's houses when there's really no one to apprehend anymore. And you're just saying we now have a right to go in and search for things because we're investigating?
Your Honor, I think as correctly pointed out before, there would be no dispute that the warrants are valid if Mr. Nevarez is alive.
You said something about school shooting. I think you were about to say something worth noting. Can you finish that comment?
If I could remember where I was, Your Honor, that's...
School shooting?
Oh, yes,
Hypothetical.
If there was an incident like a school shooting where the shooter is killed on the scene, but we know in his vehicle in a parking lot outside it's full of assault rifles, and there's a laptop in his home that talks about and he details what he's going to do to the school, why he's going to do it, all of those facts. Are we saying that because the police arrive at the school and they have to kill the person in the school?
Are you saying there's something comparable to that in this affidavit?
I am saying there's something comparable to that in whether or not a warrant can be issued for somebody that is deceased.
Are you saying, you're not going to answer my question. Are you saying there's something comparable to what you just said about the school shooting cases? Are you saying there's comparable to that in this affidavit? Is that
What would be, I would say what would be comparable, and let me read from the affidavit. They indicate in here, they give the nexus here. They state why the police officers are there, what street they are going to, what the initial complaint is, what law enforcement agencies have arrived there, that they have...
Your time has expired. Thank you very much. This concludes the matters that are on today's docket for oral argument. Court will take this matter under advisement. We are adjourned.